case briefs, and so much more. LSData's got what you're looking for.
In 1988, a complex dispute arose at the heart of which was a certificate of deposit purchased in joint tenancy by Ida Brown and her late husband Harry. The certificate got entangled in a twist of legal knots when Harry Brown used it as a collateral for a loan procured by their grandson, Dale Brown. As a result, Hutchinson National Bank and Trust Company found itself in a legal crosshair with Ida over who's the rightful owner of the certificate after Harry's demise. The outcome of the lower court's decision had initially swung the pendulum in favor of Ida. The Reno County District Court decreed that the joint tenancy was not broken by Harry's unilateral decision to pledge the certificate of deposit. However, Hutchinson National Bank and Trust Company stood its ground and appealed the decision. The bank, believing that it was entitled to the certificate due to its use as collateral, argued that Harry's pledge disrupted the unity of interest, one of the 4 necessary unities for a joint tenancy. The Court of Appeals, considering the previous rulings and specifics of the case, then sharply turned the tide against Ida. Drawing from Hall v. Hamilton, a precedent that allowed a joint tenancy to be severed by mortgaging, the court determined that a pledge, much like a mortgage, could in fact sever the unity of interest, thus breaking the joint tenancy. This ruling ended up drastically reshaping the legal landscape of the case, converting the joint tenancy into a tenancy in common and creating a presumption of equal ownership. Therefore, unless successfully rebutted on remand, Ida retained only a half interest in the certificate, notwithstanding that it was initially acquired in joint tenancy with her deceased husband. Providing much-needed relief for the bank, the case was reversed and remanded for consideration of other issues.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class